I am now going to take the opportunity to address a topic that may be the most serious of all legal concerns facing not-for-profit professional associations, both as an organization and for its members and staff: antitrust. Both the U.S. Federal Trade Commissions and the U.S. Department of Justice regard discussions and meetings between competitors as tending to threaten or eliminate competition because of the potential they have for leading to anti-competitive agreements. Because associations are vehicles for bringing competitors together and conduits for moving information among competitors, they have naturally been viewed with the closest of scrutiny under the antitrust laws. The unique exposure of associations to antitrust scrutiny dictates that measures should be taken by the organization, its members and staff, to minimize the risk of involvement in an antitrust investigation or litigation. Involvement in an antitrust investigation or lawsuit is singularly distasteful. Usually it is embarrassing, distracting, and expensive. In the case of price fixing or market allocation agreements, which are criminal antitrust cases, often the organization faces stiff fines, strict mandated oversight, and on occasion, organizations have been forced to disband. And if this hasn't gotten your attention, the penalties don't stop with the organization. It is not uncommon that the individuals involved, as well as the member and staff leadership, are assessed fines and jail terms. Even if an antitrust case is won, the demands upon the time of those involved can be immense. The emotional stress is overwhelming, and the legal fees and costs are astronomical. As I mentioned in the beginning, antitrust is a serious issue. The basic federal antitrust statutes in the U.S. are the Sherman Act, the Clayton Act, the Federal Trade Commission Act, and the Robinson-Patman Act. The Sherman Act prohibits contracts, combinations, and conspiracies in restraint of trade in interstate commerce. It also condemns any attempt to monopolize. The Clayton Act prohibits business behavior that tends to lessen competition or monopolize trade. The Federal Trade Commission Act reinforces the Sherman and Clayton Acts and bans unfair methods of competition and unfair or deceptive acts and practices. The Robinson-Patman Act prohibits price discrimination where the effect is to lessen competition. In addition to the U.S. federal laws, most other countries as well as U.S. states have enacted statutes similar to these. Under these statutes, an organization like ours can be sued by the agencies I've already mentioned, state attorney generals, and private entities, including companies, consumers, and other entities like ours. When organizations are sued by consumers, it's usually in the form of a class action. In the U.S., all business organizations and individuals are subject to the antitrust laws. But as I mentioned, associations face special concerns since, as by definition, organizations like NACE are designed to bring a combination of competitors together. This creates the means or vehicles by which collusive action could be taken in violation of the antitrust laws. A second antitrust problem arises from the fact that many of the most valuable programs offered by associations directly relate to areas of particular antitrust concern. Among those at NACE are membership, products and process standards, credentialing and certification, as well as statistical reporting. So how do we protect ourselves from the potential threat? First, NACE has a very clear policy on antitrust and a documented commitment to conduct its business in accordance with the highest standards of ethics and fair play. This policy can be found in the NACE Policies and Procedures Manual. It is important that you read this document and know it well. Second, there are specific guidelines or do's and don'ts that you can adhere to as a NACE member. These are found in the Association Law Handbook written by Gerald Jacobs, a leader in the field of association law. For some of the do's, schedule and attend meetings only when there are proper items of substance to be discussed that justify your attendance. And review the meeting notices or agendas in advance of every meeting you plan to attend. It should be specific, without broad topics that might look suspicious from an antitrust standpoint. Make sure the meeting adheres to the stated agenda. In general, subjects not included on the agenda should not be considered. You can also ensure that no matter of doubtful legality is brought up for discussion in a meeting. It is the responsibility of both members and staff who are present, when they become aware of legal implications of a discussion, to attempt to halt it. Should the discussions continue despite protest, it is wise to end the meeting. If this does not happen, remove yourself from the presence of the meeting and immediately report it to the NACE CEO. You can also make sure that minutes of all meetings are kept, usually by NACE staff, and that they accurately report what actions were taken. We also encourage you to invite legal counsel to attend any meeting where there is the potential for legally sensitive subjects to be discussed. This can be done through the NACE staff liaison or the staff executive office. You should inform the NACE CEO, preferably in writing, of any concerns you may have with the legality of any association policy, program, or process. And please cooperate with the NACE staff and counsel on all matters, particularly when there is a concern raised with a particular activity or item. Now for a few don'ts. Don't allow or participate in private or secret meetings. All NACE meetings, except in very special circumstances, are open to the membership and to the public. Don't allow recommendations with respect to sensitive antitrust subjects to be made during meetings, especially those related to price, production, markets, selections of suppliers, or customers. Prices should never, ever be discussed. Don't be coerced into taking part in any association activity. All NACE activities are voluntary. Don't allow policing of the industry as to how individual members are conducting their business. Don't establish programs or guidelines that are for the purpose, whether explicit or implicit, of excluding some members of the industry. And don't, without specific authorization by the NACE CEO or president, make public or private communication about policies or positions of the association. Finally, there are a couple key areas where NACE is particularly at risk and requires special care. Membership. Membership qualifications should be reasonably drawn and interpreted to include all that share the common concern of corrosion. Qualifications must be objective. Individuals and companies meeting the qualifications should automatically be admitted. All association products, programs, and services that provide potentially significant competitive advantage must be made available to non-members. The association may charge non-members a higher fee for these services, but they must be reasonable, related to the cost of providing those services, and not compel membership. And standards. The topic of standards development is complex, and it's generally recognized that when properly conducted, standardization activities are valuable and can increase productivity and efficiency, expand opportunities for international trade, conserve resources, and improve health and safety. It must also be recognized, however, that these activities, if improperly conducted, could suppress free and fair competition, impede innovation and technical progress, exclude safer and less expensive products, or otherwise adversely affect trade, commerce, health, and safety. There are some general rules that the U.S. federal antitrust enforcement agencies have declared they will use to determine if these programs are anti-competitive. Standards must not be used as a device for fixing prices, setting fees, or otherwise lessening competition. They must not have the effect of boycotting or excluding competitors, or withholding or controlling production. It's always preferable to use performance standards over design standards. Creations of standards should involve as many interested parties as possible, including manufacturers, distributors, service representatives, government, customers, consumers, and general public, to just name a few. Adhering to standards must be voluntary. Then there's meetings not supported by NACE staff. Your NACE staff are association professionals who have the heightened awareness of antitrust activities and are trained to take actions necessary to prevent this type of action before it occurs, and when it does occur, how to address it immediately. There is an increasing risk and responsibility on the volunteers and member leaders in meetings that are held where NACE staff is not present, such as section meetings, area meetings, and some technical activities. It is the responsibility of NACE members to self-police at all times, but especially when there is not a NACE staff present. These are just a few of the requirements. If you would like to discuss this further, please feel free to contact myself or a member of the staff executive team. And remember, in cases involving a challenge to standards, the burden of proof respecting reasonableness is on those who develop the standard. Wow, there is a lot here. Let me close by reiterating that antitrust violations are one of the greatest risks facing NACE, our members and staff. If you're ever in doubt, please contact us immediately.